Good evening, everyone. Recently, two of our neighboring nations have joined the elite list of countries who have implemented a privacy protection law, Sri Lanka and China, and we thought it's only appropriate to discuss these laws in our Janavarthini sessions. Today, we are discussing the law of China, Pipl. It is Ms. Reena Bengeri and Mr. Ransom Pinto have worked on it. I'll just briefly introduce the speakers. Ms. Reena Bengeri is a senior leader, having spent a bulk of her experience in IT global services, worked for Wipro and ITC Agri-Business Division in areas of IT delivery and quality management. She has played technical roles in a customer-facing capacity in US, Canada, and is based in Bangalore now. She got interested in data privacy while EU was drafting the GDPR, and she pursued a certification by PECB. Reena is now working with a mid-tier IT service company in the DPO's office as a senior leader, responsible for data protection and related complaints. Mr. Ransom Pinto has a rich and diverse experience in various facets of compliance, risk, legal, and governance. He holds an LLM in corporate law from University of Mumbai and is a fellow company secretary of the Institute of Company Secretaries of India. He is presently looking after the compliance function of First Advantage for the Northern Asia Pacific region based out of Bangalore, India. His past stints include those in Amicorp Group and ICICI Venture. He holds a certification CIPM from International Association of Privacy Professionals, and he's also a certified lead implementer of ISO 27701 from BSI Training Academy. Over to you, speakers.
Thank you, Manju, and good evening to all. Mr. Pinto, you can pitch in as we progress on the slides as we discussed. So sure. Today we will be talking about the China data protection law, which is called PIPL. The presentation has content from various sources, and these are all my personal opinion. It does not represent my organization. And here we go. So quickly to take you through what this PIPL is about. So it is about protecting the rights and interests of individuals in relation to the personal information which is being processed within that country. And it also facilitates the use of personal information by various organizations. Okay. This law is effective from November 2021. And I think it was announced way back in August, the effective date being November. So it has been operational now for about 6 to 8 months. As I said, it is designed to protect the rights and interests of people from their personal information perspective. And it covers the aspects of processing activities and rational use of personal data, right? This law also includes provisions requiring cross-border transfer, and it was submitted for the first time into the Cyberspace Administration of China, which is an organization taking care of cyber and data protection, and it's a regulatory organization within China. And what it states is that violations could be fined ranging between 7.7 million or up to 5% of a company's previous year's business revenue. So in similar lines of how GDPR's the penalty is drafted, they have given a number there. Yeah. These are all definitions. I'll just cover what are starkly different from GDPR. As I said, more or less, there is a very good comparison of how this law has been drafted. It has been, I would say, derived from GDPR's concepts and definitions. There are certain variations to the definitions. If you look at personal information and processing of personal information, they are similar to what GDPR has, right? Similarly, if you look at sensitive personal information, there is quite a good similarity of it. It covers medical health, religious beliefs, and biometric information, and so on. Even financial accounting information is covered as part of sensitive personal information. The age for children has been threshold at 14 years. Okay. PIPL uses the term personal information processing entity, which is similar to the controller in the GDPR parlance. and it uses entrusted party as the data processor parlance of GDPR. So there is a slight nomenclature here, but the conceptual definition of a controller and processor maps to what here is defined. Okay. So from a territorial scope perspective, if you look at the law extends its territorial scope to the processing of personal information conducted outside of China, and that's a typical definition even for GDPR if you see. And they have restricted the purposes to provide products or services to individuals in China where the services are being provided, and to analyze or assess the behavior of individuals in China or for any other purposes as defined by the law or the regulation. Okay. The PIPL requires offshore personal information processing entities subject to PIPL to establish a dedicated office or appoint a designated representative for personal information protection purposes. So this requirement is very similar to GDPR's requirement of appointing a EU representative for offshore controllers. I think somebody has to go on mute. Okay. So this is pretty much similar. Now coming to the consent, right? The definition of consent under PIPL is largely comparative to GDPR. It aligns with the strict consent requirements of what GDPR states. Okay, it says that it must be informed, freely given, demonstrated by a purpose, a clear action on the individual, and can be withdrawn. So it has all of those aspects of data subject rights in the GDPR context. So, but also we need to note here is that it requires a separate consent for certain processing activities, which include sharing of personal information with other processing entities, publicly disclose personal information, processing sensitive personal information, and transfer of personal data to outside of China as an overseas country. Okay, so consent has to be exclusively taken in such scenarios. Lawfulness of processing, this is another concept which we have taken. It actually, if you look at, it does not provide for legitimate interests as a lawful basis of processing, unlike in GDPR. Okay, and what it offers is from a non-consent basis is necessary to enter into a performance of contract, right? So it's expecting that if you have a contract with your employee, we need to have that is a basis for lawful processing. Okay, then if you have legal responsibilities or obligations to the individual, that also falls under the same scope of lawfulness of processing. Then in case of a national emergency or a public health need, that is also considered as part of lawfulness of processing. Then if you look at this one, to a reasonable extent for purposes of carrying out news reporting and media. So this is actually different from what we have in our typical definitions or callouts in terms of giving information on media or to public forums, right? So that is identified as a non-consent basis in PIPL. Then it says processing of personal information that is already disclosed by individuals or other lawfully disclosed within a reasonable scope in accordance with PIPL. So this is the last part of it, and any other circumstances which are required by law. So it is like, it is very specifically identified for taking non-consent base as a lawful basis for processing. So that is how it is here in PIPL. Then the definition of consent under PIPL largely aligns with the strict consent requirements of GDPR. And as I said, these are the three categories, which says that shares, we have to, if, however, the PIPL requires a separate consent in certain processing activities, namely, if you have to share personal information with other processing entities like a sub-processor situation, or when you need to publicly disclose personal information, which is a requirement of the law of China or the government requirement. And the third is the processing of sensitive personal information or transferring of personal information to outside of China from a cross-border perspective. So these are the aspects which are covered under the lawfulness of processing. Then if you look at the personal information rights, we talk about while the PIPL mostly aligns with GDPR with respect to personal information rights, it does not have the comparable language what GDPR has in terms of addressing the rights, including where certain restrictions of exemptions may apply. And it does not have any expectation on timely response of data subject requests in a GDPR context. Like GDPR expects that you have 30 days to respond to a request from a data subject. Here, there is nothing specified. Okay. If you look at then, the right to data portability needs to satisfy conditions stipulated by the Cyberspace Administration of China, which is again, there is a cybersecurity law which was enacted sometime in 2017. The right to data portability comes under that particular law from a sharing of data perspective. Okay, so that is how this right of the individuals is taken care of from a portability perspective. Okay. Let me just read out the second point. I think it's important. One noticeable change brought by the final version of PIPL is that the individuals will have the right to bring lawsuits against processing entities if they reject the individual's request to exercise their rights. So this is an important aspect where they have empowered the individuals to reach out to court of law in case there is a rejection of their rights, of their requests for personal information. Okay. Then it says, along with that provision that changes the burden of proof of privacy related suits and that allow individuals to be compensated based on the actual damage or the illegal provisions obtained by processing entities. This provision could provide more incentives to individuals. So they have empowered the individuals who are involved in this kind of scenario for personal data. Okay. Now coming to cross-border transfers. Aslem, you want to take up this? You had some inputs also here.
Please continue. I'll chip in as you continue.
Yeah. So I'll quickly tell a gist of this. See, what we have read through and understood from the cross-border requirements of PIPL is that the data transfer requirements are covering the provision of individuals' data specific to transfers when they are when the data has to be transferred to any other country outside of China. There has to be a specific consent which needs to be taken from the individual. That is one. Second, adopt necessary measures to ensure that the overseas recipients can provide the same level of protection. So it's in GDPR parlance, it is expecting that there are appropriate technical and security organization measures for secure processing of data. That is second. And then there has to be a privacy impact assessment which is to be taken up. So these are the three requirements which are called out in the law. Okay. Then in addition, for CII operators or entities processing a large amount of personal information, they need to store the personal information locally. So this is the localization aspect which is brought in. So that means if there is a requirement of transferring of data to outside of China, the requirement of the law says that the data has to be locally stored as well. And it has to pass a security assessment which will be administered by the authorities. Okay. So I don't know how operationally this will be executed, or at least I have not seen any articles which talk about typical flow of such a requirement of overseas transfer of data in a situation of at least a mid-sized company. But this is yet to be seen. We have to do a little more research to understand how this has been implemented in a scenario. Then for other processing entities, they can choose to obtain a personal information protection certification or to conclude an agreement with the overseas recipient basis the standard contract. So basically they're expecting that there will be a standard contract between the two entities, one within one who is in China and one who is the entity who is processing the data outside of the country. So it's like a DPA in that scenario, and that there has to be a relevant provision for covering the technical and security measures. That's the essence of this expectation. And similarly, they're talking about some standard contractual clauses, which we need to explore to see how this looks like. I have not come across a contract between a company which is in China and a processor who is outside of China to understand how the cross-border aspects are addressed. So this requires a little more research from even my side.
So the standard contractual clauses have not been provided by the under new rules have been put up for this. So as of now, even the thresholds referred in the earlier section for transferring large amounts of data have not been really articulated. So as of now, this whole provision, I would say, is kept in abeyance as to a wait and
Yeah. Okay.
can do. Consent can be taken, but the other provisions of security assessment or getting the SCCs done, or getting a third party certification is not yet. No rules have been formulated for that as yet. So as of now, we see this as just only the consent is something that which can be implemented as of now.
Yeah. So this is about the personal information protection impact assessment. So broadly, if you see from a comparison of GDPR, the concept has been taken that you need to do a privacy impact assessment of personal data processing when there is a processor involved for delivering services, and they have called out the essential elements when this has to be done. And if you look at from GDPR perspective, the call out is that if there is high volume of data or sensitive personal information which is being processed by the processor, a data protection impact assessment needs to be done. In similar lines, they have called out the same aspects here. Yeah. However, the threshold of the number of records for processing is not called out, as Anselm also said. Yeah. Now coming to the penalties and private rights of action. If a processing entity violates the requirements under PIPL, regulators may order it to take corrective actions, issue warnings, and then confiscate illegal income, suspend services, or issue a fine. And this fine can be up to 50 million RMB or 5% of the organization's annual revenue. Okay. And they have not called out global revenue and so on. Okay. Then, since the PIPL does not set a minimum penalty, regulators have wide discretion. So if you look at this discretion can be used this way or that by such organizations who are coming under the radar for penalty. Okay. Then the processing entities will be liable for tort damages if they infringe the rights and interests of personal information. And there's an article 69 which is referred here. So this also requires a little more deep understanding in terms of how this has been, because there's no news, at least I have not come across, in terms of any penalties which have been levied to any organizations, because this law is just over 6 to 8 months old in the execution in China. Then the concept of joint processing and interested processing. So this is a concept which they have introduced, which is similar to our, the concept in GDPR of joint processors, which is called actually sub-processors, right? And it calls out saying that PIPL provides that where there are two or more processors jointly determining the purpose and method with respect to processing of personal information, their respective rights and obligations shall be agreed on, which means that there has to be a contract between the two processors for where they are sharing the personal data processing activities between the two entities, right? And the law imposes joint and several liabilities on joint processors if the joint processing activities infringe any of the personal information rights and interests and result in damages. So the expectation is to have liability covered by both the joint processors. Okay. Now, where a processor entrusts a third party to process personal information under PIPL, the processor must supervise the processing activities of such third party. So, in this situation, it's like a GDPR, in GDPR parlance, you will have a processor and a sub-processor. So, the responsibility of secure processing of personal data by the sub-processor is held with the processor. In the similar situation, they have called out that the processor must supervise the processing activities of such third party. In this case, the third party would be a sub-processor. Okay. So it says such entrusted third party is required to undertake necessary measures to protect personal information in accordance with PIPL. This is the same as putting technical and organization measures in place when a sub-processor is processing personal information. And if you look at even as a best practice, we ensure that the sub-processor who is processing this personal data on behalf of the processor in a GDPR situation, technical and organization measures are assessed prior to entering into a contract with the sub-processor. So that's how this also needs to be approached from a PIPL perspective. Right now, yeah, Anselm, you can go through these slides where you have called out certain implementation as scenarios and nuances. Yeah.
Sure. So while the law has been come out as the effective date has in November 2021, we've seen a lot of the requirements which are the more implementation measures, as they may be called, have not yet been released. Important one about them is relating to security assessment and certification and SECs, which are all in connection with the international cross-border transfers. So there's absolutely no. There's a draft regulations which was released somewhere in the end of November, and some updates were given in December, but it was only put up for comments. After that, till now, till May, we haven't heard of any final release of those regulations. So as of now, we have not received any of that, any information as to when this will be, the guidelines will be, or the implementation measures will be released. So the SECs also, standard contractual clauses, also have not been promulgated as yet. We people are really, I mean, entities are really watching for the data localization, because that's important part. It would obviously mean that if data has to be stored in China, it would involve obviously cost, and there'll be a lot of changes have to be done from technology standpoint. So again, and this obviously depends upon what the categorization or the thresholds for large personal information processors, which again has not been released as yet. So as of now, this data localization and cross-border transfers are both in abeyance till we get further implementation measures released by the authorities in China. Moving on to the next one is there is a requirement for DPO or PIPO, as it's called in China under the PIPL. So under this also there is a threshold of the amount of PA that can be processed, for which PIPO has to be appointed. But that threshold has not been released as yet. So there's a PI, a personal information specification, which was released 2 years ago, 2020, but that was only a guideline, and it was not mandatory. But if one had to take that as a reckoner for what the thresholds could be, it would mean that you have to be processing of personal information of 1 million individuals, and you should be processing or expect to process 1 million information of 1 million individuals. and SPI, sensitive information of 100,000 individuals. For smaller the main businesses processing, then the number of employees should exceed 200. But then again, this is only a possible threshold. We'll have to wait for the final implementation measures to be released. Now, once you've finalized a PIP or a DPO, you have to inform the public has to be informed about this, the name of the and contact information of the DPO, and that would most likely be done by putting it up on the website through your privacy policy. The other part is that the name and contact information should also be registered with the authority, which most likely will be the CAC, Cyberspace Administration Council. Then continuing on the specification, so if you again look at the specification which I mentioned about a DPO or a PIPO, you should the requirements were that, again, these are indicative, as we say, because those specifications were only recommendatory and not binding. So we are assuming that some of these requirements could flow into the implementation measures for a DPO. So here, these specifications have specified that you should have, the PIPO should have a relevant experience and data protection experience, expertise for that. Also, and he should be involved in important decisions. And how do you judge somebody as involved in important decisions? Is that I would look at that they should be involved in the change management process, or in release of any new products where or you were involved in the when any privacy standards have been introduced for a new product. So that particular important decisions have to be taken by the DPO should be involved in that, including privacy by design or the privacy by default. And again, the DPO should be directly reporting to the principal of the organization, or whoever manages the local entity involved there. We'll go to the next slide.
One thing which we are, at least I need to maybe deep dive a little bit, is whether there is a call out on the data breach reporting aspect. I have not really understood that, or at least I need to do a little more research on it. I have not come across this in terms of a call out as such. Okay.
Sure.
Yeah, go ahead.
So continuing on the qualification part of it, is that again, while again no prescribed norms have been laid out as to what would be the statutory requirement for a DPO or a PIPO, but from a more from an industry standpoint, people are looking at that the requirements will be that someone has to be located in China and obviously speak the local language, and has obviously local information, contact information, and responsibilities at the local level. So unlike other laws, I mean, especially in Philippines, Singapore, and Korea, which I am the DPO in India. Obviously, I'm assuming that I will not be able to take up this role here because of if this requirements come up to play here. But this is again something that we are assuming that it will flow as a requirement, but we have to wait and watch till the final implementation measures are released. This is, we can leave that part.
That's about it, I think, from our side. We can open for questions, if any.
One question that I had, how about the responsibility or accountability of the government in China? While we know what to expect in China, but still for the sake of uh, uh, asking, and can the government do anything and everything, and is there any degree of accountability on the government for processing any personal data, or they can do whatever they want?
Sorry, but are you talking about the government as processing its data by the government, or
Yes,
how will
yes,
they be
yes.
able to?
Yeah, processing of data by the government.
Yeah. So that's they are treated as the same as any of the other participants who are regulated under these particular provisions.
Oh, you want to say they've put some limits on the ability of the government to process personal data, really, in China?
It covers all regulations here. I mean, all it covers all entities. So
No, I think your question was not clear, Subaraidu. Can you repeat, please?
Yeah, see, for example, in most democracies, the laws have tended to even include the government under the ambit of the limits to processing of personal data and the purposes for which the personal data can be processed and all. For example, national security, and all of these things are subject to review for institutions. How is that provision handled in the Chinese law?
I don't have a comment on, because I have not come across that kind of explanation in any of these readings which I had. So I will make a note. Maybe I'll have to research it.
I think they have a separate provisions for those things. This is only for this. I think applicability is for private parties that are processing.
Yeah, perhaps yes, that's what my expectation was, knowing China.
Exactly.
Good.
So I would assume that the European Union might not consider the Chinese privacy law to be adequate as per EU standards.
Yeah, it is not actually as of now.
that process
Even
will take place.
PIP.
The intention is that the provision is there also for mutual adequacy, and it's one of the for cross-border transfer is the expectation is that they will be seeking such mutual adequacy status from most other countries. So I see this, at least personally, I'm believing that a lot of the provisions are flowing from very similar to GDPR in many respects. So unless there's something which is not in line, but it seems that the intention is to get that status.
Correct. So if you look at theoretically, all countries will go for that, but it's a matter of time for China to come across adequacy, is my reading of things.
Yeah, because the MNCs are creating so much of a noise about the certain provision of the Indian law.
Right.
Now, for example, if this law were to completely exempt the government, okay, then how would the situation be any different from, let us say, the situation that prompted the European Court of Justice from revoking the EU-US Privacy Shield?
Yeah, agree. Yeah.
Navi, sir?
Yeah, see, the law anyway applies only for processing of data within China. So as long as EU is not sending the data for processing in China, they need not be bothered. I don't think anybody will send personal data into China. Okay. In fact, companies who are operating in China should be concerned about the personal data of their employees. Okay, because that is what may have the impact on GDPR or whatever is that. But since it is going to be applicable to data processed within China, you can't apply another law overlapping onto this. Okay, so that is one observation. Second, China doesn't have privacy, particularly in the government context. So the question of bringing government under this law does not actually make any sense, I suppose.
So, but when it regards the adequacy decision of the EU, then if the government is not under the ambit, I guess the EU would
They
never.
will not be bothered. Do you think China government bothers about getting adequacy from EU? Okay. They have framed the law just as a eyewash kind of a.
Exactly. Right.
So anyway, I don't think any sensible EU agency will send the data for processing into China. They may send it to US, therefore there is a need to have an arrangement on the privacy shield. They may send it to India, so there may be some requirement as far as India is concerned. But I don't think they should send any data of EU citizens for processing into China. It is not a hub for say data processing, no, that way. That's actually BPO kind of activity.
Agree.
Okay. So what you ask is perhaps is a theoretical question, but practically it may not be having any requirement. In fact, as I told you, the only place where worry could be there is about the employees of a European company or any Indian company which is working within China. Their employee data, China government will definitely access. Okay, China government will access our data sitting here, so why can't they access it there? You remember that one of the security guidelines US and others operate is if anybody travels to China with their mobile and laptop, after they come back, they will have to sanitize that. Because going into China and coming out, it is expected that there will be the government intrusion into the system.
Yes.
So that is the level of trust the world is having on China. Okay, so that's why I have not been very much enthusiastic about this PIPL. It is there on paper.
It's an eyewash, as you said.
Yeah. And
smoke screen.
Some people say it is a strong law. Where is the strong law if the government has got 100% surveillance there?
Yes.
At most, they might use it as a pretext to clamp down on some of the Chinese companies like Ant Financial or the type of situation to send them to jail on some pretext or the other.
Correct. Yeah. Vasantika, you have got any views?
No, I agree with you. That is, in fact, I thought the Chinese regulation is also to clamp down because they will not have adequacy, so they cannot access data of other countries. They are, trying to prevent their data from going out as a counter. So that is like, if you don't let me access yours, I won't let you access mine, kind of a regulation.
Yeah. So the purpose is to prevent Chinese data going out.
Correct. That is all they care for.
Yeah. Anyway, it's good to at least know that they are also passing a law. Ultimately, there is a difference between what is there in the statute books and the implementation. So in some countries, the implementation will be weak and law may be strong. But in countries like China, whatever is the law, implementation will be strict. So it doesn't make much of a difference.
Law is only cosmetic in nature to show. Same is the case with intellectual property rights. They are the most violators of brand name, but they are the propagators of a very strong law. Law is there in its place, not being implemented.
Correct. Yeah. Fine. Yeah, any other questions from people? Mr. Kauta is having any questions?
No, sir. No.
Does it also apply to the so-called Greater China, for example? Does it apply to Hong Kong as well?
No, I don't think it is applicable to Hong Kong. Anyway, Reena?
No, I have not come across that specifically, so I don't assume that.
No, I saw somewhere that it is not applicable to Hong Kong.
Yeah, they have a separate.
Does this apply? I think it applies to the People's Republic of China. That is.
That is the
Yes,
mainland.
yes.
That is the mainland.
But their interpretation of what is People's Republic of China is also depends on the mood of the day, right?
Yeah,
may
our
apply to-
interpretation and they may be different.
It may apply to Arunachalam. The Arunachal Pradesh.
correct. Right.
I'm a little surprised to see that the age of minor child age has been taken as 14. I think this is the only regulation that's gone so low on the age, right? I've seen 16, 18.
Some European countries have got 14.
They do?
13 also.
Yeah.
Yeah.
I don't remember the exact country, but I think some countries have.
Because GDPR is 16, if I remember correctly. And
No, GDPR gives permission for individual states to fix the age.
Okay.
Deepak says working age in India is 14. What? That is maybe for child rights, perhaps.
Yes, sir. When
Yes.
to take them as an employee,
For
certain these things.
That is why under the Child Rights Act, perhaps.
Yes.
Yeah. But for contractual purposes, it remains 18 or 21, depending upon the legal guardian. Okay.
Yes, sir. That Indian Contract Act.
So in that case, the working age, if it is for 14, then the contract will have to be with the parent or the guardian.
Guardian.
Salary has to be paid to the guardian. Otherwise, it will not give a proper discharge to the payer. I don't know. I'm just making a comment. I don't know about that Child Rights Act. Unless somebody else.
That is how it should be. But most of these below 18-year employments are in places where there is no contract per se between employer and employee.
No, because
So then
Deepak said officially working age is 14. If officially, if somebody has to be appointed, then if it is an employment contract, it has to be with the parent.
So like a lot of these schools, they promote this summer internship or project-based engagements. So, so wherever there is a remuneration considered, if it's free, it's free. I mean, you're just coming over for experiencing. That is one part. But if there is a remuneration or there is a company agrees to give you
refreshments. It is not a binding contract like scholarship receipt or something like that. It will not be a binding contract, but in the interest of the minor, payment is made out.
Right.
Okay.
So Reena madam, one more question. Does it also have some similar extraterritorial applicability like GDPR? So all the Chinese employees working in Pakistan, China-Pakistan economic corridor and all that stuff. So their data should also be safeguarded properly by.
Yeah, that is covered through those processor kind of relationships, right? So they have called out that there has to be appropriate measures for secure data processing. That is how it is called out. So it's like in GDPR parlance, it will be processor and sub-processor relationship. So that is covered.
Okay. So it also has extraterritorial jurisdiction, right? Like GDPR.
Yes.
That is if the company outside China is processing the information in China.
Correct.
Okay. But what you said is employees working in Pakistan, then their information is processed in Pakistan. So Pakistan law should be applicable.
But if Chinese residents are there, say for there are so many constructed ones.
The data is, it's like employees in India. Say, even though in India, many people think that European companies can impose their law on Indian employees of their country. If the data is processed within India, it has to be within the jurisdiction of the Indian law.
Correct.
So, and also even in GDPR, there is a provision to say that activities outside the scope of EU law will not be covered. So
Okay.
this working in India with whatever employment conditions are there, this is not subject to the scope of EU law. Therefore, it is outside GDPR. I think a similar provision should be interpreted even in what you said, Chinese employees working in Pakistan.
Mhm.
See, in all these data protection laws, applicability is to a kind of data. Now, that data has to be personal data, one. Second is it should belong to the applicable population, whatever the Act defines. We should not, in my opinion, openly apply it in overlapping terms with the data of which is coming under different countries. Okay, if you try to do that, you will be actually creating a duplicity of controls, which in practice it will not work. At least Indian law has taken this, recognized this, and has said that we will give exemptions if data is processed in India and that data belongs to non-Indians. And if the company requests for exemption, we are prepared to give that exemption. Other laws like GDPR have not made a specific mention of it, but I don't think they will be actually imposing GDPR on data being processed in India.
Yeah, agree, sir. Yes.
Yeah, any other questions? Mr. Ramesh is missing, I suppose. Yeah, Ramesh is not there. Adepo, you have got any questions, or Anil?
Reena madam,
Yes.
see, as GDPR is defined a adequacy for other countries, but this China law defining any adequacy for any other countries?
No, we discussed in the beginning of the questionnaire session. I think that adequacy question itself is not there, or I don't know whether it will evolve over a period of time, right? Because we talked about a situation where the data of Chinese employees of a company in China is being processed by any other country outside of China, and any other countries' employees' data is there in China. So the second part is not true, because I don't think any European Union countries have shared their data with China. So the adequacy evaluation itself doesn't arise.
No, recently we have some information where Sri Lanka has liberalized their approach towards China. So the business relations are being strengthened between China and Sri Lanka. The export imports or geographical liberations have happened. So in that case, whatever the data from China coming into Sri Lanka, is it anyway affected this law? This law affect that situation?
No, so it is talking about having relevant technical and organization measures for secure processing of data in that country where the data has been transferred. But from an adequacy evaluation perspective, it is not articulating any details on that.
Okay. Colonels are asking.
No, but given the current situation, I think that's not really relevant. We'll have to see how the situation evolves over the next 6-8 months between Sri Lanka and China, I'm saying.
Colonel sir, I'll put a question, please see that.
Yeah. Is there any fundamental right assured in the constitution, if there is one in China? In the absence of any fundamental right being assured, what is the use of these privacy norms being legislated?
I am not sure. Maybe Navi sir can answer that.
No, they say they have got a constitution. Okay, if that is the question, there is a constitution, and it says under the constitution there is a requirement to protect the personal information rights. Okay, so it is again a statement. Practicality, we don't know. I've never traveled to China, so I really do not know what is happening there.
But it is not an inalienable right to a citizen, I hope.
India is a very peculiar country where judicial review is possible. So whether something is there in the Constitution of India, then it becomes enforceable. But in many other countries, it is not enforceable. It may be there in the books, but it is not enforceable. India, it is more than enforceable, actually. Even when there is no rights, people will go to Supreme Court.
See, law is made to bring enforceability. Otherwise,
Correct.
we had moral laws, ethical laws.
We are a
cannot be
working
enforced.
democracy, so everything will go to the Supreme Court. But in China,
No,
even
China law cannot be called as law in the real sense.
definitely. I don't know even if the US law can be called as free as India. That is, Supreme Court of India is perhaps more free than the Supreme Court of USA, I think. I don't know. Others may disagree if you want. Because the appointment of judges in USA is a presidential decision. Yeah. Am I correct?
You are 100% correct, sir.
Whereas
we are
in
the
India,
most liberal and most spoiled.
India,
as far as
Prime
right
Minister
to
cannot
speak.
appoint the Chief Justice, no?
Yes.
Yeah.
So President or Prime Minister cannot appoint. So to that extent, it is much more free.
I don't call it as in much more free. I call it as in-house adjustments. Legal fraternity have done most disservice to the democracy of India.
You can blame the fraternity, but you cannot blame the political system. Political system cannot interfere.
The political system is made to adjust their requirements so that in legal fraternity, no accountability will be there. Today, you see a judgment of a great person coming after 30 years, and that too is given a special diet now. What is the use of that kind of punishment? That's where it takes 30 years to decide for the wisdom of the judges to come out. If that is B, we don't want such a system. It's a rotten system, fully corrupt practices. One judge allows him with a fine of 1,000 rupees. Then another judge says for 1 year rigorous imprisonment, and now they give concession of food. Do we require such kind of legal system? It's a rotten system to be thrown out. We need to amend our constitution so that accountability is built into judiciary, like executive as well as other systems we are trying to bring in. Accountability we are bringing into governmental work to some extent, but automatically it is totally free for all in legislature, in the judiciary, and judiciary, it's an understanding between the fraternity. The lawyer becomes the advocate, advocate becomes the judge, and he becomes the public prosecutor also. So they are all playing in-house game. It's an in-house team playing for themselves to prosper, not for the country's survival. That's what I feel. We are in a very frustrating judicial system in the world. Need to be dismantled left, right, and center.
Okay. Words of wisdom from an experienced person. Okay.
Okay, I think that's all we had.
Yeah. Manju?
Thank you, madam. Manju.
Thank you.
Thank you, Ms. Reena and Mr. Pinto for a very in-depth study of the law and presenting it to us in detail. Thank you everyone for the discussion, wonderful discussion afterwards. Thank you. See you next Wednesday.
Thank you, Reena madam. Thanks a lot.
Thank you, Reena.
Good night to everyone.
Yeah.
Good night.
Thank you. We shall meet again.
Thank you, everyone. Good night.